Hi, I'm attorney Ben Schwartz. Today we're going to answer a viewer question from Caleb in Havre de Grace, Maryland. He said essentially he's got a personal injury case and wants to know what is the difference between a mediation and an arbitration. And the answer is that the two things really have nothing to do with one another. A mediation is a settlement conference. It's a conference where you and your attorney, if you're represented, you and your attorney go to the mediator's office, and the defense attorney and the defendant or the insurance company that's going to be paying the settlement goes to the mediator's office too. And the mediator is generally another attorney that has nothing to do with the case. It doesn't necessarily have to be an attorney, but generally it is an attorney or a retired judge. And the mediator meets with both sides. That's called caucusing with both sides. And the mediator tries to bring a case, both sides together, to bring about a settlement. This is something that happens all the time. In fact, just this morning, in a serious personal injury case resulting from a car accident, I served as the mediator, and I successfully brought the two parties together, the plaintiff and the plaintiff's attorney and the defense attorney and the insurance company representative. I brought the two sides together and we settled the case. So sometimes I serve as mediator. I also sometimes serve as an arbitrator. An arbitration is a completely different animal. It is not a settlement conference at all. An arbitration is a mini trial, but instead of going to court and having a judge and a jury, the parties to the case, the plaintiff and the defendant, pick a neutral lawyer to serve as the judge and jury. They go to that arbitrator's office. They provide the arbitrator with the documentation. Let's say if it's a personal injury case, they would provide the arbitrator with records and reports talking about the injuries that came from the accident. They might provide a copy of the police report if it's a car accident case. They might give the arbitrator photos of the vehicles so that the arbitrator can see where the damage was, so that the arbitrator can determine how the accident happened. And then the arbitrator listens to both sides testify, and the arbitrator makes a decision. The arbitrator either says, I find in favor of the plaintiff, or I find in favor of the defendant. If in favor of the plaintiff, then the arbitrator has to award damages, meaning the arbitrator has to award the plaintiff some amount of compensation. In arbitration cases, arbitrations are typically binding or non-binding. So a binding arbitration, once the arbitrator issues the decision, that's it. The case is over. The parties are stuck with that decision. If it's a non-binding arbitration, then whoever doesn't agree with this arbitrator's order can appeal it. And then if you appeal it, it typically starts the case over as if you didn't go to arbitration, and now you're going to be on the trial track for a trial with a judge in court or a trial with a jury in court. So that's the difference between mediation and arbitration. It's the difference between an informal settlement conference versus an informal trial in a lawyer's office. Caleb, I hope that answers your question. If you're watching this video and you have law-related questions for me, send me an email, ben.schwartz@schwartzandschwartz.com. I'm happy to give you any kind of information I can to give you a general background education on how things work in personal injury cases, wrongful death cases, criminal cases. I'll do whatever I can to help you get the information that you need to understand how things work and understand what your rights are. Thanks for watching. If you have questions, shoot me an email. I'm attorney Ben Schwartz.